I'm Ted Hunter, founder and managing attorney of Sound Law Center. Sound Law Center provides hearing services, mediation services, training, and review of codes for legal defensibility. Today what I'd like to discuss with you is procedural due process and how we conduct hearings to ensure compliance with procedural due process. That's important because if you comply with procedural due process, your decisions and land use processes are free from liability, and you will not have an appeal that results in liability for your city or county. There's several important steps in complying with procedural due process. The first is that your hearing officer must comply with appearance of fairness. Appearance of fairness is a Washington state legal doctrine, first announced in case law, now encaptured in statute. It requires that the hearing officer not only be fair, but appear to be fair. So that's important that if you have any conflicts of interest, that you remove yourself from holding that hearing and go forward only if you appear to be fair. Second step of procedural due process is adequate and reasonable notice. You cannot hold a hearing until you can show that proper notice has been given. Once that has occurred, you're free to open the hearing and move forward with it. Third step is actually conducting the hearing. Now this is where a trained professional is most useful and helpful. Yes, elected officials can do it and have done it for years, but it's where they get into trouble. And in this state of Washington, there have been many cases that have found liability for not conducting a hearing in the proper way. What that means is holding a hearing that allows for cross-examination when appropriate, that allows for the record to be developed, that marks exhibits, that holds testimony under oath or affirmation, and all of the complex steps that go into making a hearing fair so that it complies with procedural due process. The next important step of procedural due process is writing a legally defensible decision. This is really important that citizens involved in the process be able to understand the decision, but also that it meets the test of the law, which means that every finding is supported by an exhibit or testimony, and that every conclusion is supported by a finding. So these steps of appearance of fairness, proper notice, proper conduct of a hearing, and writing a legally defensible decision are all key components of procedural due process. At Sound Law Center, we've set up a system that involves checklist, and it involves evaluation and review of how we do these procedural due process steps to help ensure that none of our cities or counties where we serve will be found to have any liability for a land use decision that we make. And I'm proud to share with you that of over 3,000 decisions we've made in the past years, we've not had one case where there's been any liability found for that city or county. And our appeal rate is less than 1%. So I hope you've enjoyed this brief introduction to procedural due process. We do offer it as a training component of a 2 to 4 hour session. We'd be pleased to provide it for your city or county. And you can get in touch with us through our website at soundlawcenter.com or by calling me directly. I'm Ted Hunter, 206-628-0700. Thank you for your attention today.